Hi, I'm Dan Zimbarar from Homeowner Law. I'm recording this vlog in February, which is in the first quarter of the calendar year, which is right in the middle of the season for Common Interest Development Board member elections. Now, I want to premise this next comment with a little bit of background. I used to represent homeowner associations. In fact, I did that for about 13 years before switching sides. So I think I can say this next comment without too much bias in favor of individual homeowners. And that is, California courts construe legal challenges to board action with great deference to the association to the boards themselves. In fact, there's a seminal California Supreme Court case from 1999, Lambden versus La Jolla Shores, that supports that thesis. Now, that dealt with maintenance issues, and I found other courts pretty much apply that rule to maintenance, what decisions a board may make on selecting contractors, vendors. However, there is an exception to that general deference rule, and that involves board member elections. And that's why I wanted to record this vlog, because in my experience, challenges to board member elections probably in the top 5 issues that come across my desk. What's the law? Well, Davis Sterling, which applies to governance and common interest developments, their chapter 5100 deals with board member elections. And one of the first provisions is that the association shall adopt election rules, and they must provide for equal access to association media. What's association media? Association has a website, if it has a newsletter, if it allows posts or candidate statements to be in common areas such as a lobby or a mail kiosk, it must do so uniformly. The association shall not redact or edit any of the content. However, the association can put in a disclaimer that it is not responsible for the content. So if a candidate is going to insert some type of controversial, potentially discriminatory, or illegal content, well, the association can at least protect itself from liability with that disclaimer. One of the next provisions is that the association rule shall specify the qualifications for voting, such as use of proxies. There's an entire section of the statute that goes into details of proxies and their use. Bottom line is a proxy cannot be used in lieu of a ballot. One of the next provisions is specifying appointment of 1 or 3 inspector of elections. Inspector of election must be independent. What does that mean under the Act? Well, they cannot be a current director, cannot be a candidate for director, it cannot be a family member of a director. In addition, an employee of the association or a business that is under contract with the association cannot act as an inspector of elections unless the association rules expressly authorize that. That's one of the areas where a governing document can deviate from the statute if it expressly states. I know in many instances, professional management companies or managers will act as inspector of elections. They can do that only if the association's rules allow for that. In addition, the rules may allow nominations from the floor. One of the other processes and protocols for elections in California is the use of the secret ballot. There are 2 subchapters in the statute, 5120 and 5125, that cover the details of a 2-envelope system, verifying signatures and voting. Pretty detailed protocols there that are described in the statute. And lastly, if there's going to be a legal challenge to the election, it must be done within 1 year of when the cause accrues, which normally would be the date of election. We covered a lot of material, pretty much the 10,000-foot level, but as you can see, it's fraught with peril, and that courts will apply strictly the laws and rules regarding elections. Hopefully, your board member election goes along swimmingly and you don't have any issues, but if you do, or if you have any questions regarding the process, make sure you contact competent legal counsel. Thank you.